So you resolve your retainer issue, and your client then says to you, look, I've been working at this corporation for a period of time, or these allegations of fraud are related to documents, emails, accounting records, whatever it may be, and Jonathan, here are my records and my originals, and I'd like you to review them and tell me what you think about my case and my defense. Well, you should be aware of something. Just like it would be improper for you to take the knife or the gun that was used in a crime into your possession out of concern that you as the lawyer might be being used as a dupe and could potentially face allegations of an attempt to obstruct justice, you can also fall into that same danger with documents. So after the Ken Murray case was decided, Ian Scott, who prosecuted the case, wrote a quite compelling article about why the smoking gun concept also applied to documents. So if your client walks in and says, Jonathan, I cooked the books and I kept one for the accountants and one separately, and here are my originals, you as a lawyer are now faced with an ethical obligation about whether you should receive those documents. Just like if the client walks in and says, here's the gun. You should first of all tell your client that you're not going to accept that documentation. Second of all, if your client is insistent, you should be saying to that client, if I receive that documentation, you have to be warned and understood that I may have an ethical obligation at some point, if this is evidence of crime, you've cooked the books and you've given me the 2 copies, to turn that over to the authorities, which could in fact enhance the prosecution against you. So don't be fooled that just because you're dealing with documents, you don't have the same ethical obligations that you might if you're handed the knife or the gun by your client charged with an offense of violence. So the question is, well, what do? You need as a lawyer perhaps to review that documentation and look at that documentation to best advise your client. Well, the answer is, at least in accordance with what Ian Scott wrote about it, who prosecuted Murray, was if you take copies of those documents and return the originals to the client with an instruction that they are not to be destroyed, edited, or tampered with in any way, and they are to be kept in a safe place where the police, if they executed a search warrant, could locate and seize those documents, then you've met your ethical obligation. Because the challenge for the lawyer is you don't want to be seen to be attempting to obstruct justice. And if the client is depositing original documents with you in the hopes that they'll be sheltered in some way by sitting in a lawyer's file, and therefore frustrating potentially the police from executing search warrants and obtaining the documentation, then what you do is you take copies. And you can review the copies with that very clear instruction to your client that the original should be kept in a place where, in theory, if the police choose to execute a search warrant, the police can obtain those documents. And then you as the lawyer don't run into the ethical risk that Ken Murray unfortunately ran into many years ago. So those are just 2 ethical issues dealing with the retainer and documentation. Now your client gets charged. Your client is charged with either a small scale or a large scale fraud. And what do you need to know in order to best assist your client? Well, first of all, you should know that the prosecuting authorities have a very strong interest these days in the post-Enron, post-Bernie Madoff, post-Earl Jones environment in prosecuting white-collar crimes. There are, in fact, even specialized police departments out of the RCMP that focus exclusively on white-collar crime. So, and generally speaking, the police are very well trained. They're very capable in putting together the documentation and putting together a case. I know we have someone in the room who's now a defense lawyer who actually used to work with IMET, which is the RCMP police force, and they're very capable at what they do and in producing the documentation. So you all of a sudden are faced with, as we were in this case that Paul was referring to, here's a hard drive with 1 million documents. Go ahead and run your defense. Okay? The first thing you should know is there are not just dumping disclosure obligations on the Crown. There are obligations on the Crown to present the disclosure in an accessible fashion that allows you as a defense counsel to properly review it and properly prepare your defense. And we've had that issue litigated in our office previously about ensuring that the defense has the same tools the same software programs that the Crown has in order to organize and access the relevant materials. And that's critical. It's not meaningful disclosure if the Crown has a concordance software or some other type of software that allows them to do a word search and pull up in a split second the 5 emails that your client sent relating to the second set of books, and you're faced with 1 million documents where you're either printing them out or trying to view them on a screen one by one to figure out if those documents exist. And generally speaking, I can tell you again, the authorities being as well organized and funded as they are, they're actually quite fair about that. But that's a good starting point when you do get that disclosure to ensure that you have the same capacity through the prosecuting authorities to search and access the documentation. And so in this case where we got a hard drive with 1 million documents, the RCMP officers actually came to our offices, assisted in installing the software, and gave us a seminar on how to search properly. And that's the way it should be. And if that's the way it's not happening, then you as a defense counsel can take steps to ensure that it does happen that way, because you are not able to defend your client effectively without that type of organizing software. So now you've got it all organized through the assistance of the prosecuting authorities, and you say to yourself, what am I supposed to do with 1 million documents? How in any way am I supposed to put together a defense? And I can tell you that it's critical, of course, in any case, but particularly critical in cases of fraud, that you engage your client in a very meaningful way in the defense of the case. If it's an accounting case, if it's a books case, if it's a failure to disclose to the board of directors an insider transaction, whatever it may be, your client will often be the best assistance to you. Because you may have a case, as Paul was talking about this case where we had, where the suggestion was that a piece of land was flipped by members of the officers and directors of a corporation for private gain without disclosure to the board of directors. And on its face, we understood why there was concern about that transaction, and frankly why the authorities had investigated, at least. And whether they should have prosecuted, we'll leave that for another day. But at the end of the day, through the discussions with the various clients, and there were multiple clients who were charged, it was very clear that at the time when this occurred, which was the pre-Enron days, that the custom had been that those types of transactions were not disclosed to the board unless they were over a certain amount of money. So one of the things that we had to do at the trial was raise a whole series of other similar transactions that our clients told us about that had been treated in exactly the same fashion by the directors and officers, by the board of directors, and by the accountants, who said, this is our practice, and this is our custom, and this particular transaction that ended up being the focus of the trial was not handled any differently. So first of all, you need to engage your clients to the extent you can in understanding what documentation may exist and what explanations they may have for the documentation that may seem damaging. And emails these days are killers in all of our cases, whether it be a criminal harassment case, whether it be a conspiracy case, and in particular whether it be a fraud case. So you need to engage your client. And some clients can help you and some clients can't, but you need to at least have that discussion with them. The next thing that you need to do in all likelihood is, aside from, we're assuming you've gotten over the hurdle of your speaking with senior counsel who may be assisting you or working with you on the file, you probably need to engage the services of an expert, because there may very well be accounting issues. And Paul talked about the cross-examination we were engaged in on our big fraud case, and I can tell you that for days and weeks before we stood up to cross-examine the accountants who were engaged in the investigation and the prosecution of this case, that we were meeting almost every night with our own forensic accountants who could explain to us what the documents meant and whether the conclusions that were drawn by the accountants for the prosecution were correct or incorrect or complete or incomplete. All right? So the hiring of an expert, generally speaking, in fraud cases is also a critical piece. And that leads me to another important area, and Enzo, I know, is going to speak about it. I think Paul will speak about it now, which is the hiring of an expert. Yeah. I was very fortunate that one of the roles that was assigned to my office was that we were counsel to Commissioner Gouge on the Gouge inquiry into pediatric forensic pathology in Charles Smith in Ontario. So the issue of experts and the role of experts in the criminal justice system is of, I think, particular interest to all criminal defense lawyers, but was something that I was fortunate enough to have a bit of a close-hand view of for a couple of years. Your expert should be held to the same standard that the Crown's expert should be held to. Your expert is there to assist you and help you in explaining the documentation as it relates to fraud, explaining if there are accounting records, or explaining how this fraud was allegedly structured and successful or not successful. Your accountant should be fair and neutral and objective, and should not see himself rise that a similar principle should apply to your defense expert. Now, there are some different issues based on solicitor-client privilege and what your client is, able to explain to, for example, a prosecuting authority. But the moment when you say your expert is going to take the stand and testify, you can expect that the Crown may very well seek access to the expert in advance. And they're entitled to do so. And if you have the good expert and the neutral expert and the fair expert and the qualified expert who's assisted you with your defense, you shouldn't care. Because that expert is there to assist you and to assist the court in understanding complicated issues. Now, a couple specific practical tips. When you advance an expert to the court, whatever communication the expert has had with counsel, whatever rough notes or rough drafts they've made of their reports, those can be compelled to be produced to the Crown. Just like if we have an expert on the Crown side who's drafted a final opinion, then we're entitled to get the materials behind that opinion. It works the other way as well. So as counsel engaging an expert to assist you in a fraud case, for example, or in any case, you should now think very closely about how you communicate with your expert. Email is so easy. But remember, your emails to your experts will be producible. If your expert hits the stand and starts giving an opinion based on a report, the Crown's entitled to get everything behind the report, and that includes, at least in theory, but I think in practice, the email correspondence between counsel and the expert. So to be frank, I now communicate with experts more often by phone than I do in email. Because I may want to give instructions, I may want to have frank and open discussions that are all covered by the umbrella of solicitor-client privilege without worrying that one day those may be exposed to the open view of the court. Not because we're suggesting anything improper or unethical, but because we do, as defense counsel, with our experts, we do have an entitlement to a zone of privacy and privilege to protect and advance our client's interest with those experts. Okay? So make sure your expert is somebody who not only testifies in an ideal world for the defense, and this is all cases, that expert should also testify for the Crown. It's one of the first questions I call when I call an expert. I say, do you testify for the defense? Yes. Do you also testify for the Crown? And if that person says to me, no, I don't testify for the Crown, generally speaking, I'm looking for another expert. Because I want someone who's fair and objective and whose opinion will be accepted and well regarded by the court, and that's not an advocate. The expert's role is not to be an advocate anymore. So be careful about the experts you choose. And that includes, of course, in fraud cases, quite often forensic accountants are involved, and forensic accountants need to be carefully screened by defense counsel to ensure that they're well regarded and objective assisters of the court. Okay? Now, you now have your expert, and you're working with your expert, and your expert is assisting you in understanding the documentation or what other evidence there may be in relation to fraud. What are they looking at? What is it that the expert is going to assist you with in terms of a legal test? Well, I'll give you the citation. The leading case on fraud in the actus reus and the mens reus Theroux out of the Supreme Court of Canada, Theroux. The site is 1993 2 SCR 5. And what Theroux tells us and guides us on the law of fraud is that fraud, in essence, as many of you probably already know, and forgive me if you do, is deceit and risk of deprivation. So if somebody engages in some deceitful act, whether it be a cooking of the books, whether it be an omission, whether it be a failure to disclose, whether it be lying in order to obtain funds from somebody, whether it be lying to get access to credit or finances from a bank or mortgages. That the first element of fraud is deceit. And your client has to be proven by the Crown to have engaged in an intentional deceit that puts somebody else's usually financial interest at risk. It doesn't have to achieve the goal. You don't need an actual loss or a deprivation to make it a fraud. You just need a risk of a deprivation. So if you engage in some deliberate and intentional activity that you are trying to run a Ponzi scheme to get money from people and you fail miserably and you never make a dollar, you're still guilty of a fraud. People don't actually have to lose money in order to be victims of fraudulent behavior under the criminal code. What the courts and of course the prosecutors are more interested in is what did your client know at the time and what did he or she intend to do, and did they turn their mind to their deceitful act or their dishonest act and say, we're intending to do this in order that potentially somebody is at risk. Go ahead.
Let's say when a client comes to my office, had bad credit at one point.
Can I just, I'm just going to stop.
Sure.
Sure.
Hey, Jonathan. Just asking the question be asked at the mic for the benefit of those that are on the webcast.
Sure.
So a client comes into the office, applied for a credit card using falsified information because they had bad credit at one point. Always intended to pay off the credit card, did pay off the credit card, closed the account. There was never any sort of shenanigans with it. It's just they got the credit card deceitfully. Is that fraud?
Yeah. I mean, I think it could be more than fraud. First of all, you run the risk that it's an utter forged document.
Yeah.
You've created a document and lied and falsified a document in order to obtain access to credit, or a credit card in this case. So you have a potential utter forge. And second of all, it may very well make out a fraud. You have deceived, you've engaged in a dishonest act in order to obtain something for yourself, and you've put somebody else at risk. It doesn't matter that the credit card company never lost $1. You may have paid off every single Visa bill that you got. The reality is you've put yourself in a position and you've put the victim, in this case the credit card company, at risk of losing money. And they haven't been given a fair opportunity to understand the real facts or truth about who you are and your background in order to make a proper assessment about whether a credit card should be issued.
So even if your intention, and I won't sort of ask any more follow-ups after this, but even if your intention is to honor the contract with the credit card company, so you don't have the intention to deprive, you just have the intention to get access to the credit, that's still sufficient?
Yes. If you have the intention to engage in the dishonest act or the deception, and you're putting somebody else at risk, that's sufficient.
And in preparation for this, Jonathan and I were talking last weekend, and one of the things that we were talking about was you can go one step further. They may have turned a blind eye to what you put on the application, and they didn't really rely on the deprivation or the misrepresentation, I should say. Still a fraud. I'm not cutting off.
You can cut me off.
No, we have a question from, and I forgot to indicate this earlier, if anyone's watching by way of webcast, and if you have a question, please email it to me at paul@barristers.com, and I'll vet them, and if we can get them in, we're going to get them in. There was just a request for a clarification, and I know that you were going over Ian Scott's article.
Yes.
And it's very important. And I just wanted you, if you could reiterate what the requirement is. Somebody's bringing in those documents to you. They're the smoking gun. I think that you laid out the proper foundation on how to deal with it. If you could just go over it one more time,
Sure.
I'd greatly appreciate it.
I'd be happy to. So we could just use the smoking gun example because it impacts people, I think, more than the cooked books does. So a client comes into your office who's either being investigated or has been charged with murder and says, he pulls out of his pocket, puts it on the desk and says, here's the gun. This is the gun that was used in the murder, and I want you as my lawyer to accept it. So the question that raises ethically is whether you as the lawyer should be taking into possession evidence that in fact proves the crime. And the simple answer is no, you shouldn't be. So because you don't want to be seen, first of all, to be obstructing the course of justice by trying to conceal evidence by virtue of working in a law office and privileges, that you're now hiding the gun from the authorities. You're now an accomplice, in essence, to the crime. So you don't want to do that. So what other alternatives do you have if you take that into your possession? Well, you can't destroy it. It's evidence of crime. That in and of itself is a crime. You can't tamper with it. That's a crime. So what are your obligations? Well, the Murray decision would say that your ethical obligation is, in all likelihood, to turn that gun over to the authorities. Because you as the lawyer cannot be used as a dupe for your client to hide evidence of a crime. Now, it's no different with the documents. With the documents, if you have the set of cooked books in front of you, you're faced with exactly the same dilemma. You're being asked as the lawyer to keep and maintain and potentially hide from the authorities the documents that prove the offense. So the answer ethically should be, no, I cannot take these into my possession. Second of all, if you insist and you walk out the door and you won't pick up that gun off my desk, you won't take those cooked books off my desk, I want to tell you that according to the decision in Murray, I may have an ethical obligation to turn that gun or to turn those books over to the authorities. Because I can't attempt to obstruct justice as a lawyer. I can't hide evidence of a crime. So I have to turn that over. Now, with documents, there's a relatively easy solution, because you as the lawyer are concerned about an attempt to obstruct justice, which is trying to conceal evidence from the authorities. If you make copies of the documentation and maintain the copies, and return the originals to the client with an instruction that they're not to be tampered with or destroyed in any way, because that's a crime, then you have met your ethical obligation, because the police can still conduct their good faith investigation and have access to the materials that they're entitled to pursuant to a legally executed search warrant. And you are now in a position where you can review the documentation in order to best assist your client. Now, I can tell you that's a controversial decision, or a controversial article about Scott, to be fair, and there are some lawyers who would say you could take the documentation. But I'm warning you to be cautious when the prosecutor in the Ken Murray case talks about what your ethical obligations are. I think that's an article worth heeding. So I'm just warning you of that. I hope that explains, and if it doesn't, I apologize.
I think that's wonderful. And when I introduced Jonathan, I told you how I was impressed. And I can see just by the audience how everybody's impressed. Thank you for your time.